Job losses have resulted in many South Africans not being able to meet financial and contractual obligations. The Independent Tenants Association have approached the High Court on behalf of its members to rule on the interpretation of rental clauses insofar as they relate to the COVID-19 pandemic. However, according to a corporate and commercial law firm, Cliffe Dekker Hofmeyr, if performance of a contract or certain obligations in terms of the contract become impossible due to unforeseen circumstances or events, the parties are excused from performing in terms of that contract. Now, to discuss this further, we are joined by Dr. Ivor Blumenthal, who is the founder and CEO of the South African Independent Tenants Association. Great to have you on the program. Thanks very much, Dr. Blumenthal.
Thanks for having me, Leanne.
So, why, in a nutshell, has the Independent Tenants Association approached the High Court to rule on the interpretation of the rental clauses insofar as they relate to the COVID-19 pandemic? And basically, I suppose, in a nutshell, what are you contesting?
So, Leanne, what we're contesting is the fact that whereas the president asked tenants to close their doors and shut down during the lockdown period, and essentially that when they open up, there is a need to recognize there's also a recovery period once you've opened up. The same rules, the same laws don't apply to landlords, which means that landlords have an expectation that they can continue to charge two things. Number one, for rates and taxes and everything they have to on-pay, including security costs, etc., which my guys have no argument about paying. And the second component, which is rent. My guys, the independent tenants around the country are saying if we're locked down or if our business is negatively affected, you cannot expect business as usual. You cannot expect us to continue to pay our rents. And the bottom line is what they're saying is that we want the High Court to rule that landlords cannot be above the law when everybody else is subject to the law. Because in most of these agreements that these tenants have by landlords to have any hope of being in a retail environment is to basically say, as landlords, irrespective of natural disasters, irrespective of force majeure, you're still going to have to pay us everything you owe us as rent. That's the bottom line. We are above all of those incidents. And we're saying to the High Court, how can that be fair?
Let's perhaps give some practical examples. Are there many cases where you're finding that landlords are demanding that tenants pay their full rent, even though they've been basically shut for all of these months? They are only now picking up, and still, the business is not back to normal. It really isn't. You find a lot of people are still staying away from shops. They're very, very scared. And with all these job losses, people just don't have the money that they used to have in terms of spending. So are the landlords demanding that rental that they had been demanding pre-COVID-19?
So we're finding two groups of landlords. The one is the group of landlords who are prepared to drive their business into the ground because obviously they want a tax write-off, spending on 100% of their rent, irrespective of the fact that tenants are locked down. They're not deriving any kind of income. And then we're finding other landlords who say, well, all right, we're going to give you some percentage, a discount at our discretion as landlords, irrespective of what the law of the country says, at our discretion, but we're going to want you to sign another year's lease if we give you 1 month's worth of 20% discount or even 100% discount. If you want 2 months' worth, we're going to expect you to sign a 3-year lease with escalation so that ultimately we get our money back. The majority of landlords in that second group are saying, we're not going to give you discount, but we'll defer your payments for a year thereafter, which means we want our money irrespective of the disaster, the state of disaster in this country. And we're saying to the High Court, surely that can't be fair. There has to be a shared risk. And that's what your introduction, where you spoke about percentage of turnover, because in our estimation, that's the only way to share risk in a controlled way. But we're very far away from getting the courts to agree with us in that regard. We realize it's an uphill battle.
I can imagine. I mean, that's another battle to face. But right now, your hands are full with this battle. So let's talk to the law and actually let's lay it out. What does the law actually say on the rights and obligations of both parties in this kind of predicament?
Well, at the moment, the way those contracts are written, they're written in terms of the law, which is heavily balanced in favor of the landlord and absolutely anti-small business, absolutely anti-retail tenants. But the law says what's in the contract is in the contract. So if you put a clause into the contract that says that as a landlord, you contract out of the negative effects of force majeure or an act of God or a state of disaster, then the courts will enforce that aspect of the contract. Now, we're saying that's unfair. A landlord should not be entitled to contract somehow out of the consequences of force majeure. And we're saying to the courts, re-examine these clauses in these lease agreements. Look at force majeure, look at act of God, look at states of disaster. Look at the president saying, guys, you have to shut down for 2 months to save lives in this country. Say that landlords cannot contract out of some kind of an obligation in this regard. And that's what we're saying. We're saying the law needs to change, maybe, but the law needs to be interpreted in a better way, equally, at least initially in the short term. And down the line, Parliament needs to come to the protection of small retailers in this country and make new law that says that as far as small retailers are concerned, that landlords that can run rampant over these guys and drive their businesses into the ground and go after sureties to make sure they get their money at the end of the day, that's insidious, that's evil, that's criminal.
Yeah. And this is the case that you find with a lot of small retailers. And, we talk to these small business owners because they seem to be the ones that really are on the brunt end of all of this. I mean, your bigger guys, just to give an example, like if you look in your shopping centres, your key tenants, as they call them, your Woolworths, your big Zara's, your H&M's, your massive stores, your Checkers, they don't feel this at all to a certain extent. But it's the small guys that are the ones that almost appear to be having to pay more than the others do. It doesn't weigh up. And this has been a massive gap in this industry for a very, very long time. Is this something that you've been looking at for a while, or has it just been exacerbated due to COVID-19?
So SAITA was first established in 2014, principally because of what you've just said, that it's the small independent retailers that are keeping the cash flow going in the average shopping center. The big guys are going in and because of their muscle and because they're destination stores, they're able to negotiate rental agreements that essentially say, I'm going to pay water and light, a little bit of operational overhead, but don't expect me to pay rent. I'll pay percentage of turnover at the end of every year, but on a month-to-month basis. It's the small retailer who has to go in and has to find the 30, the 40, the 100,000 rand every single month, irrespective of the turnover that they're doing. Landlords say, tough, you're a small guy. You don't have the same bargaining power as the big guys. That's why the South African Independent Tenants Association says, we talk for the guys who are doing less than 50 million rand a turnover. Now, when you talk to the landlords, and we know this through the property industry group that was created because of COVID, landlords define small as companies doing more than 80 million rand turnover. Those aren't our guys. Principally, our guys are the guys who are literally making between 10 and 50 million rand a year turnover. And they have very little, or they've had very little negotiation power up until now, but that's changing.
Yeah. So let's now focus particularly on, and I know you've touched on it a little bit in terms of the lease agreements that have been signed. Are there clauses in these lease agreements for these unforeseen events and uncontrollable events? Not necessarily, like a flood or a storm or whatever it may be, but of a pandemic, such as what we're going through right now. Has this even been accounted for in terms of these lease agreements?
The clauses say, irrespective of whatever the event is, we still want our money. It's that simple. These lawyers have managed to put together an agreement that says, irrespective of whether it's a pandemic or any other act of God, whatever it is, we want our money. Now, if you're asking about a pandemic specifically, the insurance companies have known for 15 years that is a pandemic on the horizon. In fact, some of them have warned some of their clients, shipping clients, about the fact that, there's a pandemic on the horizon. But you have to talk about why specifically insurance companies and landlords have kept this thing about pandemic so quiet, just wrapped up within this notion of force majeure and act of God. So the reality is the average lease agreements don't specify pandemics. They don't say, we're not going to be liable if there's a pandemic. They just talk about acts of God. They talk about supervening impossibility. That a natural disaster, for example, somehow doesn't affect them. And that's what we're going after here. ridiculous that they can somehow be above the law and everyone else subject to the law.
Yeah, two more issues to touch on before we end the interview. In terms of the consideration, and have you taken into consideration that in some instances the landlord themselves depend on these properties as a source of income and also have to pay back a bank, for example?
So the bottom line is what landlords have really enjoyed doing over the last 3 months is saying to my guys, my members, my small tenant, retail tenants, go to all of these funds that have been created and ask for money because we're not going to help you, but government set up all of these funds. Well, we're saying exactly the same thing to landlords. All of the banks are giving you dispensations. The only time a bank won't bend over backwards for you, Leanne, is if you owe them money. The only time a local council won't defer payments, if you ask them to defer payments, is if you've not been paying your rent. What many of my tenants are finding is when they say to the landlord, why should we pay rates and taxes to you when we know the municipalities are giving dispensations to landlords? Yeah. And the landlord says, but they haven't given it to us. Invariably, we find that 75% of the time, the reason municipalities or banks don't want to give dispensations to landlords is because landlords have not kept up with their payments. So they've taken the money from my guys, but they've not paid it over, either to the banks to pay off their debt or alternatively to municipalities in terms of rates and taxes. So my guys end up suffering.
Yeah. So this almost like throws my next question out of the interview, because I'm basically going to ask you is if government actually went ahead and decreed a moratorium on all of this, do you think that would help?
So they did it. At the beginning of COVID, government put out what they called a block release, which said to landlords and said to tenants, get together, get around the table and talk to one another and try come up with a better solution for the tenants and for you, the landlord. What happened is that the landlords got together, they formed a big confederation called PIGS. Believe it or not, that's not my term, that's their term, the Property Industry Group. So they formed a big confederation called PIGS, but then they refused to get around the collective table with the tenants on the other side of the table. And they said, rather, we'll pick these tenants off one at a time because we know we can bully them better. That's why SAITA stepped up and said, that's not going to happen any longer. Yeah. We reflect the interests of those small independent tenants collectively, just as PIGS does it for the large landlords.
Yeah, and that's something to take into consideration in a massive way when it comes to, we have an entire ministry that has been set up that is meant to protect small businesses, and yet it doesn't seem that that's the case with what you're talking about. The industry that's bearing the brunt of COVID-19 are these small businesses that are shutting their doors. You drive through the streets of, obviously I live in Johannesburg and this is a nationwide thing. It's the small businesses that have shut down, not the big guys. The big guys they're having a great time, but the small businesses right now. Have you known of any evictions over this time? Because we know that this is not allowed during COVID-19 lockdown period. But do you know of the tenants that have actually been evicted?
So we've got about 30% of threats. We have no application for evictions at this moment in time, no summary judgments which the courts have even considered. In reality, the courts won't look at this as a matter of urgency, but rather as a matter of contract. And what we're also doing, by the way, in launching this legal action, we know that our members who are in the legal action are covered for the period of the lockdown, which is roughly about 2 months, and thereafter at least for 6 months for the recovery period. So we know that when a small tenant joins this legal action, they are covered for that recovery period by something called lis pendens, which means that the landlords cannot go after them for debts incurred in that 8-month period while we're trying to sort this out in the courts of law. It doesn't mean that tenants aren't responsible for their debts before COVID or debts after COVID. But that 8-month period, we're ring fencing in terms of protecting our members.
All right, so let's just get the details of this. When are you actually appearing in the courts? When is this going to be heard?
It's going to take a long time. We know that because we doubt very much that the courts are going to deal with this as a matter of urgency, even though we're going to ask for it to be done. We also know that if we succeed in the High Court, there will be an appeal to Bloemfontein. And we know ultimately this thing will end up in the Constitutional Court because a lot of this is a dispute of interest rather than a dispute of right. It's not something that's been settled previously. So we know we've got a big fight on our hands. But the reality is ultimately, we want Parliament to rule on this. We want Parliament to change the law and come out protecting small and independent retailers in this country and do their job, because Parliament has been noticeable by its absence in this regard.
Dr. Ivor Blumenthal, I think you've given small businesses and particularly those in the retail sector a lot of ammunition now to help them through this time, because it is a very, very difficult time, and anyone you speak to is struggling right now with that relationship between the landlord and the tenant, and they don't know what to do. So hopefully this has given them some advice. You, of course, the founder and CEO of the Independent Tenants Association, talking to us about the rights of tenants during this particular time. Thanks very, very much again for joining us. Right, the time now, 8 o'clock on this Monday edition of Morning Live. Let's get our latest news bulletin from Sakina.